The matter of application by Noeleen McAleenon for judicial review.
Mr. Southey.
My lords and my lady, I appear with my learned junior, Minford, for the appellant in this matter. My learned friends, Mr. Cole, King's Counsel, and Dr. Anthony appear for the first respondent. For the second and third respondents, my learned friend, Dr. McAleenon, King's Counsel, and Ms. Mulholland appear. Sorry, I was just waiting. Can I immediately raise one concern, which is the email that we received from the court yesterday in response to the letter from my instructing solicitors of the 26th of April, which was about ground 2, the materiality. Obviously, the context of this is that the order granting permission indicated that ground 2 would only be considered after remittal being determined, and obviously remittal hasn't yet been considered.
I don't think it did say that.
Sorry?
I don't think it did say that, did it?
I think it did.
I think it said that we might hear argument in relation to ground 2.
Sorry, it said permission to appeal would be considered after oral submissions on remittal.
Yes, we gave permission on ground 1.
Yes, exactly.
The panel gave permission on ground 1 and indicated that, in other words, the application could be renewed in relation to ground 2.
Well, it reserved the position in relation to ground 2.
Well, it reserved the position,
yes.
But we didn't say that we would not be considering it.
But the concern I have is that, obviously, the position of all parties, what it indicated was that remittal would be considered first, and the position of the parties was that the appellant's position is it should be remitted. The respondent's position is it should be remitted if it's not academic, and we've got arguments obviously about whether it's academic or not. The concern I have is that the time estimate to properly advance the case in circumstances where obviously there was no permission test applied by the Court of Appeal. It was an appeal as of right. To properly advance the appeal, which is essentially that would have been heard by the Court of Appeal, it will take a significant amount of time. Now, I'm certainly intending to and will explain why we say there was an issue for the Court of Appeal to determine, partly because it's relevant to understand what the nature of that issue is. But I am concerned that full development of those arguments in circumstances where there was an appeal as of right to the Court of Appeal is going to take, would require additional time.
Well, was any approach made to the court to say that 1 day wasn't enough for this case?
Well, what we did was approach the court in the manner that we did, indicating that we understood that the position of the parties was in favour of remittal.
But the letter didn't say anything about the time estimate.
It didn't, on the basis that it understood that the agreed way of dealing with the matter was remittal, subject to the issues about whether the matter was academic. But, my Lord, I will deal with the issues in the way I can, but all I'm really putting down is a marker in one sense about the fact that this was an appeal as of right. That meant it would have been fully developed in the Court of Appeal. In the time available, I have to impose restrictions on myself in terms of how I will develop it here. But that's all I'm really indicating.
Thank you.
Can I deal with that in mind? I want to deal with 4 areas, essentially. First, what were the issues before the court, at the Court of Appeal? Secondly, what were the alternative remedies? Thirdly, the law on alternative remedies. And fourth, the issue of whether the appeal is academic. Can I take you first to, which is at page 370 of the electronic bundle, the re-amended Order 53 statement setting out the grounds in support of the judicial review application. Now, these were dated, and there's some significance to it, the dates at the end at page 388, the 2nd of March. Now, the significance of that date is that that was after the Richards judgment in the Court of Appeal. Now, they were re-amended after a contested hearing before Mr. Justice Humphreys, at which the court needed to be persuaded, essentially, as to what was arguable and what was not arguable. It was there is no judgment, unfortunately, from that judgment. But Mr. Justice Humphreys went through saying you can retain this, you can't retain that, effectively. And that means it's wrong to say that, in one sense, Richards was, as I think the second and third respondent says, Richards means that the jurisprudential basis was terminally undermined. This was a case where effectively the Order 53 that had been amended, re-amended I should say accurately, had been one where the court was satisfied there was something to be heard despite Richards. That sort of development of the case in parallel with Richards also explains why the evidence was in the form it was. There had been, perhaps unsurprisingly, a desire to adduce evidence to run arguments that would have succeeded on the basis of the Richards approach in the High Court. By the time the substantive hearing was heard, reliance on the expert evidence, for example, had largely been put to one side because the issue was much more focused on the arguments that had been essentially accepted to be arguable despite the Richards Court of Appeal judgment. Turning to those arguments, in relation to the first respondent, if you go to page 375 of the electronic bundle, you will see, sorry if the copying isn't brilliant because of the colour that was used, the grounds in relation to the first respondent materially alleged a failure to comply with the duty imposed by Section 64B of the Clean Neighbourhoods and Environment Act, Northern Ireland 2011. And that responsibility had been left to other bodies, in particular, effectively, the second and third respondent. That, we submit, was a straightforward public law issue, failure to comply with statutory duty. It clearly covered a period of time because any failure to comply with the duty to investigate will take place over a period of time. There was also arguments in relation to the first respondent about misdirection, perhaps less material given where we are now, and that's ground 1B. Consistent with that, the relief sought...
Sorry, ground 1B. Oh, yes, I see it. Yes. In the green.
Probably the most realistic form of relief that was likely to be ordered included a declaration of a failure to properly investigate. You see that at 373 Roman 4. Now, the judgment of the High Court can be found at page 252, where this is dealt with. It's paragraph 59 that we'd like, if I can take the court to. '59 includes starts with a citation of Section 64B, which I will take you to for other reasons, which requires or imposes a duty to take such steps as are reasonably practicable to investigate the complaint. Mr. Justice Humphreys then directed himself that meant there was a statutory duty and the council was entitled to determine the means by which that duty is satisfied. The legislative provision recognises there may be different ways as to which different ways in which to comply with the obligation. and it finishes with the direction that the discretion must be exercised in accordance with the objects of the statutory duty, but only impugned on grounds of irrationality. Now, on appeal, and this was the primary point made in relation to the, and I'll give you the reference to the appeal grounds in a minute, but it's probably convenient to hold this page open for the moment because of what follows. And what we continue to argue is the case. The point that was essentially being made is that the statutory duty, as set out by Mr. Justice Humphreys, is not to take steps that are reasonable. It's not to take steps that the District Council determines are reasonably practicable. It is, on the face of it, an objective duty to take such steps as are reasonably practicable. And the word practicable in our submission means that the focus is on the extent to which a step can actually be carried out. It's an objective duty. Now, that is an issue that, in principle, could arise both in England and Wales and in Northern Ireland. There is, as far as we're aware, no case law directly on it. In the court below, the first respondent relied on ex parte Anne, which I'll give you the reference to. It's volume 2, tab 31, page 5526. Paragraph 45 is, well, 44 onwards are really the relevant paragraphs.
Sorry, paragraph?
44 onwards. 44 and 45, actually. What you see there is that the issue in that case was not a challenge to the steps that had been taken. It was primarily a challenge to whether the conclusions reached regarding statutory nuisance were reasonable. And in that context, it's not surprising there was a concession that conclusions reached are subject to a reasonableness test. In fact, to the extent this overlapped with what was an issue here, which was the steps taken, if you look at paragraph 61 of the judgment, the judge appeared to assess for himself, albeit it's not clear how much, to be fair, this was an issue and how much it was argued, the judge appears to have assessed for himself whether the steps were reasonably practicable, which reflects the fact that, as I say, it's an objective standard. Now, the problem with that, compliance with that duty here, is clear if you, and it's why I asked the court to keep open the passage of Mr. Justice Humphreys' judgment. If you go to paragraph 60 of the judgment, you will see that Mr. Justice Humphreys correctly, and I don't think there was a respondent, I'm pretty sure there wasn't a respondent's notice challenging this from the first respondent, that the decision maker, or the person who gave evidence rather on behalf of the decision maker, Miss Courtney, had directed herself, essentially indicating essentially that the second respondent had primary responsibility. And that's clearly wrong because, I'll come on to the statutory scheme, there are two separate statutory schemes here, one of which applies to the first respondent. And that, on the face of it, in our submission, suggests that there was a failure to do all that was reasonably practical. Even if the test, in fact, is right, that the question is whether it's reasonable, it suggests at the very least, when assessing what was what steps should take, the council misdirected itself by focusing on the roles of other public authorities.
Well, I mean, not necessarily. She just seems to say they have the primary responsibility, which suggests that the council also has a responsibility. We just don't know from that paragraph. Well,
and this is one of the
reasons to investigate.
The argument, just to sort of develop it a bit further, based on the evidence, was that certainly for a significant period of time, what the council was doing is saying, in response to complaints, go and contact the second respondent, basically.
Well, they had a parallel regulatory jurisdiction, and it was well within the discretion of the council to identify their jurisdiction, wasn't it? Well,
no, for this reason, if the statutory obligation had been, and this is why I say the issue turns on the meaning of section 64B, if the provision had been that the council shall take such steps as it regards are reasonable, or then the issue might have been different, because it would have placed primary decision-making responsibility on the council, and for it to just simply decide what was a reasonable step. The obligation we submit is more demanding, because it is an obligation to take not just steps it regards as reasonably practical, steps that are objectively reasonably practicable. And that's a more demanding obligation, essentially. It imposes a positive obligation to do everything that is reasonably practicable. And that's where the issue comes.
That includes referring to the parallel regulatory jurisdiction of these other agencies.
I'm not saying you can't, it's not including it, right, but I'm saying that's not enough, and certainly for
well, it may not be enough, but you said, ergo, there is an error of law. Well,
the error in law, sorry, I'm obviously trying to deal with this relatively quickly, but the error in law in our submission is, in relation, there are also arguments, in one sense, on the facts about what the evidence showed. But the reason why we highlight that in particular is that if your primary response is to essentially say, go to the other authorities...
But they did, that wasn't their primary response.
Well, this is what...
Not on the evidence I've read, anyway.
Well...
it was a part of the response, but they investigated, they met, they sent out odour diaries.
That was only after a period of time.
I mean, the judge has made a finding in paragraph 61 that the evidence does not sustain the assertion that the council abrogated responsibility for the investigation, and goes on to say, and here's what they did.
But again, that comes back to what we say is the misdirection in paragraph 59, in the sense that if you approach this on the basis of which is what we submit, ultimately the judge appeared to do, if you approach this on the basis that the statutory test is for the council to do what it regards as reasonable, paragraph 61, setting out steps that were taken, in our submission, then we would recognise is unproblematic. If the test is, we say it is, and that's taken from the statutory language, if the test is an obligation, if the duty is rather a positive obligation to take such steps as such steps as are reasonably practicable, the way to approach that is not, in our submission, to look at what has been done, it's to look at whether more could have been done, because the obligation is to do everything that's reasonably practicable.
I'm not even sure what more could be done. Odour diaries, get in experts, listen to what they say.
Well,
what did you want the council to do?
Well,
go and sit in the middle of the site? What do you say they should have done that they didn't do?
Well, the part of the issue we would submit is the need for proper testing, and to this extent it may overlap with the issues in relation to ground 2 and 3, to the second and third respondent. If you don't understand what you, in one sense, you're looking for in terms of harm, and that's one of the issues that arise in relation to the second and third respondent, then it's very difficult to see how you are essentially properly assessing whether negligence whether or not there's a failure to comply with, whether or not nuisance is present, rather.
But I'm just coming back to the point I was pressing on. I would have thought that in a case like this, the obvious thing to do is to consult experts. The council obviously aren't experts themselves, and they did consult experts, and then they read what the experts told them. What? I'm struggling a little bit to see what else they could do than that.
I come back to, if you like, the point we make in relation to the second and third respondent. Nobody in this process, and this except is primarily focused on the second and third respondent, but it is a part of the process. Nobody, none of the regulators essentially actually came, in contrast, for example, with the English approach, to a conclusion as to what levels of hydrogen sulfide are safe in terms of long-term exposure.
Well, they all came to a conclusion that there was no statutory nuisance.
They came to a conclusion that, well, the first respondent, that's only the first respondent, but the first respondent came to a conclusion there was no statutory nuisance.
And that the operator was operating within the terms of its permit.
Yes.
Using best available techniques.
Yes. And I'll come on to the second and third respondent in a moment.
Well, I thought you were talking about the second and third.
Well, yeah, but the full detail of it, because that issue of best available technique, potentially, well, I recognise it has a relevance in both contexts. Can I also say that in terms of the historic response, we do raise, and I'll come on to why we say the historic response was before the High Court and the Court of Appeal.
Sorry, but I'm so sorry to keep pressing you on this. I'm just trying to get clear in my mind what you say the council failed to do. So you seem to be happy with that they've instructed experts and read the reports. Is it that they haven't understood the reports in relation to the H2S issue?
Well, the first point I'm putting in relation to it is what they failed to do was recognise the need potentially for an assessment of long-term, of the potential for long-term harm through long-term exposure. We also...
And is that something the experts said that they should assess and they didn't?
No, but that comes from...
So is that something the experts didn't tell them they needed to do?
No. The particular expert...
Sorry, I just want to be clear. When you say no, are you saying the expert didn't tell them they needed to do that?
Yes. I'm saying I accept the expert. When it's talking about experts, what they actually did was they primarily went to one expert, who a company called Tetra Tech, who's carried out a series of tests. There are issues about the criticisms of those tests, but they instructed a single. Their primary technical expertise came from a company called Tetra Tech.
Right, and Tetra Tech didn't say you need to do this long-term assessment. Tetra Tech said what we're telling you is sufficient, and the council acted on Tetra Tech's advice. Is that the picture?
From memory, Tetra Tech did suggest that there was potentially a need for further testing, but I'm talking from memory in relation to that. But
right, okay.
But what they didn't identify and accept that, because this is the point I was making, is that there was a need for long-term.
Mr. Southey, if I could just follow up on that. Did any of the respondents' expert evidence suggest there was anything further that needed to be done?
What the respondents' evidence did, and this links it, the simple answer to that is no. What the respondents' evidence...
Stay with that same answer for a moment, and just take you then to page 217, and the reference of paragraph 40 to the Sir Clive Lewis's book, saying that if there is a dispute about what should be done, for instance, and there's a difference of opinion, about which I don't know whether there was a difference of opinion, but if there is a dispute, you rely upon the respondent's evidence, because the burden of proof is on the applicant. Is that a correct statement of the law?
My Lord, I think there's English Court of Appeal authority which suggests there may be more nuance to it, but I'm not. This isn't a case where we were arguing that the argument that was being put before the High Court, just to put because it's perhaps...
Let me finish first of all, if I can, please. Okay, so I can get it straight in my mind. For the purposes of this appeal, you're accepting that statement of law.
Yes, I'm not trying to challenge that. I'm not. I wouldn't want to be conceding it for anything else, but I'm not trying to challenge it for that.
And then, if there is no expert evidence on the behalf of the respondents that suggests that anything else should be done, then surely the suggestion you're making that they haven't done anything all reasonably, objectively, haven't done everything reasonably practical, just falls away.
Well, Lord, wouldn't accept that in well, I wouldn't accept that necessarily for two reasons. One, and which is the primary reason, which is the question then becomes how their decision-making process reached the conclusion they reached. And as I say, we did.
Just explain to me how a regulator, being advised by its experts, whose evidence the court must accept, has to take some step that the expert does not recommend.
Well, my lord, fundamentally, firstly, the decision has to be one for the regulator. The regulator has to, we submit, correctly direct themselves in law as to what their duties are. And that's relevant because if they've misdirected themselves in our submission, that impacts on, in one sense, the way in which they gather their evidence. The other point I don't want to lose sight of is that there was also a historic claim, and we did make the point that for a significant period of time, the only response was essentially to say, go and raise your complaint with the second defendant, or second respondent, rather.
If you then look at paragraph 42 of the Court of Appeal at page 218, they say that if the expert evidence is approached in this manner, that is, the respondent's expert evidence is accepted, the whole basis of the appellant's case is fatally undermined. And at the moment, I can't see any possible answer to that proposition.
Well, Lord, can I come on, because perhaps it's clearer once I come on to the second and third respondent, to the second and third respondent, because I'm also conscious of time.
Okay.
In relation to the second and third respondent, there was expressly pleaded, it was in the Order 53, a rejection that there'd been what was described as an apparent, it's page 376, paragraph 4A, a rejection of Public Health England's guidance. And that was said to be an absence of due diligence, which is the Article 8 standard, and a failure to consider the interests of long-term residents.
Sorry, which bit are you reading from?
Sorry, it's paragraph 4A, page 376, right at the bottom of the page. It's
4A, thank you.
And it was also said to be essentially a failure, well, a Padfield challenge. There was effectively a Padfield challenge, failure to exercise in accordance with statutory objectives. Linked to that, if you go to the next page, paragraph 4C, it was said that monitoring had been undermined by the absence of clear standards.
Can I just check on 4A? Are you talking there about, well, who are you talking about? Where you say the guidance values apparently adopted by Public Health England have apparently been rejected. Rejected by whom?
That, I think, in context, because it follows on from 4, was in particular, except focused on the second and third respondents, because they were the body, albeit obviously they advised the first respondent. They were the body that purported to engage with and reject the Public Health England guidance.
Right. So not rejected by the first respondent, nor by their experts, Tetra Tech. Well,
their expert. It goes back to the point that their experts, on the face of it, didn't consider the issue of lifetime exposure. They didn't engage with the guidance at all. Now, that argument, we would submit, was always about effectively engagement, the decision-making process as it's expressed, rather than saying effectively it's unreasonable or the English guidance is mandatory. And so if you look, to give you two examples of that, the skeleton argument in the High Court is page 411, and it's paragraph 66C1. arguing there's been a failure to assess
Sorry, what page?
66C, sorry, page 411, sorry, my lady.
Thank you.
Paragraph 66C1. I should say that there is a reference there to 1 part per billion. It's accepted that the English guidance refers to 1 part per billion, 2 micrograms per metre cubed, I think it is. They're not actually identical, but that's how the guidelines. And I rather than get into the sort of weeds of whether it's 1 part per billion or 2 micrograms, I'm going to use the 1 part per billion shorthand because that's what it's clearly referring to. The closing written, there were then closing written submissions because the hearing took place over over a couple of days. And if you go to page 486 of the bundle, written closing submissions, paragraph 11, you will see that the argument is effectively, particularly in the middle of the page, it's proper engagement is how it's expressed. Now, to understand that, I need to give you some references to the evidence. If you, page 2098 of the bundle.
Sorry, page
2098. This is part of a paper prepared by the UK Health Security Agency, as it became, which was formerly Public Health England, in relation to Wally's Quarry, which was the subject of the Richards litigation. And halfway down the page on 2098,
I didn't get a good note of how you describe this paper. Can you just describe it?
Yes, sorry. It's a paper prepared by UK Health Security Agency, also known, historically known as Public Health England, because there are references sometimes to it being Public Health England, in relation to air quality at Wally's Quarry, and Wally's Quarry was the subject of the Richards litigation.
So was this, I don't know, was this a report specifically prepared in the context of the Richards litigation for forensic purposes,
no,
or was this a public document?
It was a public document. There is evidence in relation to it. It was a public document available as part of, in contrast to what happened at Mullaglass, in Wally's Quarry, there was like a big website with sort of details of monitoring, and this was, if I remember rightly, I think there's evidence from my instructing solicitor confirming that this was on that, this was available on that website.
Yes, thank you.
And you'll see under the heading hydrogen sulfide, halfway down 2098, there is a reference there to the health-based guidance values used by UKHSA. I should also make the point, although it's described as the UK Health Security Agency, it is effectively, for these purposes, an English-focused body. It's not a body with responsibility for Northern Ireland, certainly as far as anyone's aware. Halfway down, there is the heading saying that these are the health-based guidance used by UKHSA for risk assessment for acute, intermediate, and lifetime exposure. And beneath that there's a box, and the sort of right-hand column of the box adopts from the US Environmental Protection Agency a level for lifetime exposure of 2 micrograms per metre cubed, 1 part per billion. That's what, as I say, I'll use the shorthand 1 part per billion. There is this slight kink that they're not actually quite the same. And you will see that there is a sort of 3 stars are used then to footnote that, to explain what is meant by that. It's an estimate of a continuous exhalation and inhalation exposure to the human population that is likely to be without appreciable risk of deleterious effects during a lifetime. That is the same paper, just to demonstrate, clearly was the basis of the monitoring at Wally's Quarry. If you go to 2103, you see how monitoring levels are assessed, among other things, against that limit. Unsurprisingly, in some senses, because obviously there is an issue potentially with residents if levels are high.
Sorry, where are these monitoring stations?
Sorry, the monitoring stations were near to Wally's Quarry.
This is still Wally's Quarry.
This is all this paper is about Wally's Quarry, but it's an example. The reason I draw your attention to it is it's an example, essentially, of what became the UK Health Security Agency using this limit in practice, and that's why I draw attention to it. It's not just something they note in passing; it's something they use as part of their monitoring.
Is that the US EPA reference concentration that's referred to?
Yes.
Which is one of the columns. Is that right?
Sorry?
Oh, no, that's the line. I see.
Yeah.
Yes, thank you.
So what they were doing, essentially, certainly as I read it, is they were looking at their monitoring results and seeing the extent to which they met that. Now, that was potentially an issue in relation to Malagasy. Now, there was, by the time of the hearing, quite a lot of data potentially about the levels of hydrogen sulfide near to Malagasy. Can I just, though, take you to one example of why we submit it couldn't be dismissed as an irrelevant concern? If I take you...
Why what couldn't be dismissed?
The one part per billion, the lifetime concern, sorry. That 1 part per billion, which, as I say, I'm using as a shorthand. If you go to page 4031...
Sorry, page?
4031, you'll see an affidavit of Dr. David Cromie. This affidavit, one of its primary purpose was to correct what he'd done in a previous affidavit. His first affidavit was look at what readings obtained from a Jerome meter said about the level of hydrogen sulfide. And to avoid, I can give you the references to it if necessary, but I suspect they're not. The second respondent in particular hired this quite expensive piece of equipment called a Jerome monitor, which measures hydrogen sulfide, and carried out a number of spot checks round the area, basically. And what Dr. Cromie had sought to do in his first evidence was look at what they showed about the average level of hydrogen sulfide in the area. And he then corrected this because there was an error in it, and used 2 alternative methods of calculating what this showed about the average level. And you see, if you go to para 12A, which is at 4035, on one basis, his calculation was that there was 3.39 parts per billion.
Where do we see that?
It's 12A.
Thank you.
On another calculation basis, which I think, if I remember right, his view was probably more accurate. I may be wrong about that. But then next paragraph, 13A, it comes up as 3.31 parts per billion. Now, he discounts that if you look at para 14A on the basis that that is significantly below the levels for established short-term health effect levels. But obviously that is not what the 1 part per billion limit is, or guidance rather, is more accurate to put it, is about.
No, that's about constant inhalation over a lifetime.
Exactly, which is, but obviously if you've got residents, if you're looking at long-term residents, it potentially becomes important that. Now, the same, that's why, in one sense, or part of the reason why we argued that there was a need to engage, essentially, with that standard.
And what was, sorry, Mr. Southey,
Yeah.
what was the reading at the premises of the applicant? You've got the readings at the site, which there is evidence saying that they are 3.31 parts per billion. But lifetime inhalation is for those people who aren't on the site. So where's the evidence of that?
Sorry, my lord, I haven't taken you to the underlying evidence of where the Jerome tests were taken. No tests were actually taken at the house by anybody, at the house of the appellant. Those readings, though, the Jerome test readings were taken, if I remember rightly, away from the site. They were taken in sort of areas surrounding the site rather than in the site. I'm sure I'll be corrected if that's wrong, but that.
Thank you.
Now, importantly, the English material was essentially first reviewed by the first material we've got indicating any consideration of this was contained in minutes of a meeting from the 22nd of October 2021 at page 2754, where there is consideration. It's a meeting between the Northern Ireland Environmental Agency and the Public Health Agency. And you will see at 2754, there is consideration. It's a little unclear how it started, but sort of just above halfway down the page, initials DC, which is a reference to Mr. Cromie again. Values don't seem to be correctly, it's a reference to Wally's Quarry. Values don't seem to be correctly stated in the ruling.
Sorry, where are you?
That's sort of, the passage, I think it's about 10 lines down. It's the end of the paragraph starting DC, looking at the numbers.
Right, thank you.
And what's,
Sorry, I haven't got,
document?
forgive me.
This is a meeting.
Forgive me, I still haven't got the passage.
Sorry.
Is it DC looking at the numbers?
Yeah.
Yes, my lord.
Thank you.
Sorry, this is a document, a meeting that took place between the Northern Ireland Environment Agency and the Public Health Agency about Mull of Glass, during which there was consideration of Wally's Quarry and what was in one sense to be learnt from Wally's Quarry. That wasn't the sole purpose of the meeting, but the passage I'm taking you to is...
The date of it?
It was the 22nd of October 2021, and this is the first time certainly we've been able to locate in the evidence. I'm always very conscious of not knowing what you don't know, but it's the first time we've been able to locate any consideration being given to the approach being adopted in Wally's Quarry. So there's question marks raised about whether or not the judgment essentially correctly reflects standards. But perhaps most importantly, what is said at that stage is that the public health agency essentially will need to, it gets its own toxicological standards from external bodies and has no in-house ruling. And that's important in one sense because nowhere in this evidence that I can see, again, the normal caveat, you never know what you've missed, but is there any suggestion that the second and third respondent are in a position to reach their own conclusions about what levels of long-term exposure are risky? And consistent with that, the suggestion was there would need to be outside support. Now, that is addressed, firstly, in the evidence, both by Dr. Cromie, who we've already seen, at 4038. Where he says, at paragraph 22A, that his understanding is that the advice was given as part of a risk assessment specific to Wally's quarry. Well, you've seen the paper. On the face of it, it is not. What is being said is that is a level applied by the UK Health Security Agency based on American standards identifying what is safe in terms of lifetime exposure, long-term exposure. That may be being applied simply in Warriors Quarry.
I thought the point being made in the meeting that you showed us was that the Wally's Quarry assessment seemed to be geared to a particular vulnerable individual, which it was, I think, because the Richards case is about a boy, I think, with very particular health problems which might be affected. So he's not a representative of the general population.
The Richards litigation was about that, absolutely.
No, but the meeting was about that.
The meeting was also about that, except that. But this is more generally, this is in response to the complaint that's being made, look at the standard, effectively. And that standard, there's no indication that standard was being set simply because there was one particularly vulnerable individual living in the area. It was being set, you remember the passage I took you to as to where that standard had come from. It was a standard that was being set as it was the guidance that effectively was being used as the baseline to assess what was a safe or unsafe level of long-term exposure.
Well, I'm just looking back at 2754, which you showed us before, where it said NIEA is unsure if the ruling is going to present a new standard for all facilities which emit H2S.
Yes.
So they've looked at the Wally's Quarry material, which seems geared to, someone described, it's centralised around one sensitive individual. And they say, well, that's fine. We don't know if that's going to be a new standard across the board.
No, but what's then I made the point that's the first engagement. What we've now got to, when we've got to this affidavit, is an affidavit filed in response to the judicial review, where what is being said is you need to engage with this. So this is the first point at which this is one of the two pieces of evidence which effectively engages with the complaint that there was a need to effectively consider that lifetime limit. It's not simply you need to consider the outcome of Richards. It's the broader complaint being raised by the appellant that there is a need to engage with this 1 part per billion limit.
Sorry, this is page 4038.
Yes.
It seems to be making the opposite point. My understanding is that the UK HSA PHA advice was given as part of risk assessment specific to a particular situation relating to Wally's Quarry. I am not aware of UK HSA PHE enacting more generalised guidance. So that's not the guidance.
Well,
and if it's not the guidance, presumably you don't need to engage with it, to use your language.
You've read I'm not going to take you back, given the time, to the passage of the material from Wally's Quarry. Actually, it might be worth actually doing that. Sorry.
That's on. You said that was on the Wally's Quarry website to indicate how monitoring at Wally's Quarry was being done. That you haven't shown us anything that indicates that there is a UKHSA PHE monitoring guidance more generalised and applies across the whole of England.
My point, if one goes back to 2098, you will see, and this is why we submit it's of.
This is from the webs. This is all about Wally's Quarry. Look at the page before. This is about how they do the monitoring at Wally's Quarry. There's nothing that you've shown us so far that says this is the generalised expectation across England. And indeed, wasn't that the problem in Richards? Didn't the judge adopt the PHE methodology, and the Court of Appeal said he was wrong to have done so?
Well, the difference between this case and Richards was that in Richards, effectively the issue was about how quickly the material could be, the standards could be achieved. There wasn't any dispute in one sense about, because these standards had been applied.
They'd been applied to this particular quarry.
But my lady, the reason I don't accept that is if you look at page 2098. 2098 is setting out the methodology, which starts by looking at what are effectively safe and unsafe standards. The language used under the heading hydrogen sulfide is general language about the guidance values used by UKHSA, and that is based, it's not saying there's a particular feature of Wally's Quarry like the vulnerable child. It's based expressly because it makes it clear that their methodology is to look at recognised standards, and it makes it clear that standard is developed from the US EPA, which is obviously nothing to do with
Dr. Cromie, whose affidavit was prepared on behalf of the Public Health Agency, said that this was not generalised, a generalised standard that applied across England. Was he wrong about that?
Well, my lady, there was no evidence.
His evidence. There was no evidence to contradict it.
Yeah.
So the judge was entitled to proceed on that basis, and I don't know where this is going.
I mean, also, sorry, if I may just make a point supplemental to what my lady is saying. There seems to be a sort of fundamental problem with adopting one PPB as a generalised standard, because that's based on continuous inhalation exposure. That's when you're sitting in a room breathing this in all the time for your whole life.
Or living your life next to
if it's there, but if the wind blows and it's in the opposite direction, then that's not continuous.
But my lord,
how can one take this highly specific standard and say, oh, well, if we've got a monitoring station that shows above 1 ppb for 24 hours, that shows that there is a risk to health. I don't follow.
My lord, in one sense, our point was more fundamental than that. It wasn't, and this is why I made the point about what was being argued, and this is raised in the grounds of appeal. It wasn't that necessarily 1 part per billion was the correct test. It was that if you've got long-term residents, and there clearly were long-term residents, that was somebody who the claim was brought by, there needs to be an assessment of what long-term levels of exposure are safe. Now, had the Northern Irish authorities come forward, given what we've already seen about their own limited technical facilities themselves, and said, we've looked at 1 part per billion. We understand that is the US standard. We understand that's been applied by the UK Health Security Agency. But having considered that, we've also taken advice from whoever, and we've come to the conclusion that, in fact, long-term exposure is not a problem if it's less than 5 parts per billion, to use as an example, then I accept that would have been a judgment reached, and it would be difficult potentially to challenge. What one has here in my submission is material showing that long-term exposure can be an issue from and if you go back to the origin of it, it's from the US EPA, which is obviously, there's no suggestion that they're not a respected environmental regulator. You've got that being discounted, and I accept it's discounted on the basis that this is not Wally's Quarry, but you haven't got any sort of attempt to think or to assess what is a safe level for long-term exposure.
But I'm struggling to understand this because you showed us Dr. Cromie's affidavit, and I think I'm looking at the second affidavit now, page 4036, paragraph 14, where we may have lost Lord Stevens. I better stop.
Looks like we've lost him. Pause for a moment. 4036.
4036, paragraph 14. Oh, Lord Stevens is there. Shall we check?
Can we check if you can hear us? Can you hear us? You're muted, I'm afraid.
I lost the connection for a short period of time, and I can now hear perfectly clearly.
Thank you very much. We can hear you as well. Thank you.
Mr. Southey, I'll resume my question. So the page reference was page 4036.
Yep.
This is to, I think, Dr. Cromie's second affidavit.
Yep.
And at paragraph 14, he sets out his conclusions, essentially, that there is no health impact from the levels which have been detected. So I'm a little bit unclear when you say there's been no attempt to assess the long-term health effects, where he seems to be doing exactly that.
Well, except if you go back to 4036A, and this is what I highlighted before.
Sorry, 4036A, I don't think that's...
Sorry, 4036, 14A, sorry, I was combining
14A.
two references, paragraph 14A.
Yes.
He starts by saying overall the short-term Jerome test values using both methods were still very significantly below the levels for established short-term health effect levels. Now that raises the question of what was shown about potential long-term exposure levels. There is, on the face of it, there is in that paragraph, for example, we would submit no engagement as to what is a safe long-term level of exposure.
Yes, I see. Thank you.
My Lord, that's why I then took you to 22A in the same paragraph. You see the discounting essentially of the Wally's Quarry material on the basis that it related to the particular situation at Wally's Quarry.
And that all seems right. I don't think you contest that.
It was being applied in Wally's Quarry, absolutely. What we do contest, obviously, is its origin, is in fact of more general application. Its origin has nothing to do with Wally's Quarry. It was a US standard, effectively. And the similar approach of sort of discounting on the basis that Wally's Quarry is a different situation is discounted, is found in the affidavit of, second affidavit of Colin Miller from the Northern Ireland, who's a principal scientific officer within the Northern Ireland Environment Agency, and at 3832, paragraphs 7 and 8.
Sorry, 728 or 7?
7 and paragraph 7 and 8. Right?
What page?
Of 3832.
Thank you.
you see there that he effectively discounts Wally's Quarry on the basis of a couple of bases. One, the readings were higher. In relation to that, he picks one particular reading. If one looks at the report as a whole, that's probably not necessarily a particularly fair reading of the report as a whole, because quite clearly it was being regulated at times where it was lower. He raises then the issue of the high background measurements in other areas of Northern Ireland. The problem with that, in one sense, is that none of that means there's not a safety issue. I mean, it might mean that there are safety issues in other parts of Northern Ireland, but none of that focuses on whether actually there is a problem with long-term exposure. And that's why, as I say, the issue raised in the claim was about engagement with this material. Article 8 was also raised.
Sorry.
I'm going to try and move on because I'm very conscious of the fact I've got almost... Article 8 was also raised quite clearly. Mr Justice Humphreys correctly accepted Article 8 was engaged and that the appellant was a victim for the purposes of the Human Rights Act. That's never been challenged. The grounds, I won't take you to them, but they're at page 379M, argued essentially, among other things, that there was a failure to act with due diligence, partly because of a failure to comply with domestic law. That was also raised on appeal, Mr Justice Humphreys having indicated there was a valid and rational distinction drawn with Wally's Quarry, which hopefully I've raised. In relation to Article 8, there was an express claim about historic failure. The reference to that is in the Order 53 at page 378. That was the basis upon which a damages claim was raised, and it was clear in the High Court skeleton argument, for example, a damages claim was raised. What, in my submission, all of this demonstrates is that there were arguments, certainly got relief from the High Court, given, as I say, the argument about the amendments. There were arguments about the extent to which regulators were complying with their public law obligations, and that's the context in which alternative remedies should be considered. In relation to those alternative remedies, moving on quickly, there's no dispute that an individual can, under Section 70 of the 2011 Act, the reference, I'll give it to you, is 6153 of the bundle, bring summary proceedings for statutory nuisance. There's also no dispute that common law nuisance is a recognised ground of tort. I should just note in passing the report in the authorities at 5152 of a judgment we identify as being giving guidance on this is in fact a summary report. I think overnight we've provided a full copy of the transcript which the court should have, and the relevant paragraph on the public law nuisance test is 686. The key point, though, about both of those things that I want to emphasise is that in both of those contexts, the focus essentially is on the conduct of the landfill site and whether the landfill site has complied with its private law duties. Neither claim involves in any way a consideration of the regulator. You can succeed with the claim even if the regulator is doing a brilliant job. You can also fail with the claim even though the regulator is in fact inadequate. Now, in relation to the regimes governing the respondents, the first respondent has a positive duty. I've referenced it before, I'll give you the page reference, 6137 under section 64B of the 2011 Act, duty to take reasonable, those steps that are reasonably practicable to investigate. As I say, it's expressed in terms of a duty, and our basic argument is that that demonstrates the primary regulator in relation to nuisance. There are obviously regulation duties imposed on the second and third respondent, but the primary regulator in relation to nuisance is the local authority, and there's good reason for that. To use an example, The affidavit, and I'll give you the page reference to it, of Mr. Miller, who I've referenced before, records how the use of the Jerome monitor had cost over a 6-month period for £14,000, £14,478. That demonstrates, in one sense, why it's not surprising that the public authority is made the primary regulator. And consistent with that, we weren't relying on section 64B, but section 64A makes it clear that there is a freestanding duty to inspect, even if nobody complains. Now, my lords, that's relevant. My learned friends, I think it's the first respondent, places weight on the judgment of my lord, Lord Sales, in Glencore, where my lord emphasised that one of the reasons why, in one sense, the alternative remedy procedure exists is because it's important that the courts reflect the judgments of Parliament, effectively. If Parliament has established a statutory regime, you've got to reflect that judgment. Here, in our submission, that in one sense works in our favour, that principle, because the judgment of Parliament, quite clearly, in our submission, is that the primary regulator in relation to nuisance, I'll come on to the second and third respondent in a moment, the primary regulator in relation to nuisance is the local council, the first respondent. And so permitting judicial reviews of the first respondent in our submission does, in fact, reflect the judgment of Parliament, effectively. Well, I should say the Northern Ireland Assembly, because it's a piece of Northern Ireland Assembly legislation. In terms of the second and third respondents' obligations, those arise under the Pollution Prevention and Control Industrial Emissions Regulations, Northern Ireland 2013. Again, in the time available, I'm going to focus on a couple of things in relation to that. In particular, Regulation 9, which is found in page 6208, means that the plant in question, or the landfill site in question, required a permit. Regulation 11.1 sets out conditions for how conditions for a permit should be determined. And in our submission, this is important because it gives some idea of what the objections of the regulations are. And in particular, it makes clear that one of the principles is that there should be no significant pollution. That's in Regulation 11.1.2. Now, Regulation 2, which is found at 6204...
Sorry, 11.1.2, there doesn't seem to be 11.1.2.
Sorry, I'm talking from my own notes at the moment.
It's 11.2b, I think.
Sorry. I think it's this one. Yeah. Sorry, I've missed my notes. I was misreading my notes. I meant 11.2, not 11.1.2.
Yes. Yes.
Sorry. And pollution is defined in Regulation 2 at page 6204 as including introduction into air of substances that are harmful to human health. And that's why in our submission, in simple terms, it's important to understand what levels of exposure give rise to long-term problems, or what levels of long-term exposure give rise to problems. Harm to human health isn't necessarily just short-term. Should say also another objective of the regulations we would submit is that the second and third respondents essentially stay up to date. And we draw that from a number of sources, but primarily Regulation 17.2a, which essentially require reviews of permits to determine the significance of the pollution. And given the definition of pollution, we submit that means one needs to be up to date essentially as to what are the risks to harm. And so there was, we submit, consistent with the statutory obligation, an obligation to keep up to date, and that goes back to the merits. That's an issue in our submission that clearly couldn't be raised in either forms of negligence proceedings. In terms of the Human Rights Act, we accept...
Mr. Southey, sorry, I'm sorry for interrupting.
No.
But could you assist me in relation to one matter?
Yes.
The standard of 1 part per billion is over a lifetime. Was there any evidence at all as to whether the readings would decrease over a period of time, so that it may be 3.31 parts per billion at present? But was there any evidence to suggest that it was going to be 3.31 over a whole lifetime?
Well, my Lord, the evidence was obviously over a significant, over a number of months. The 3.3 was measured, which was the only period, because the monitoring actually only started at a relatively late stage, which is one of the reasons why there was a claim in relation to the Human Rights Act. What the evidence showed was that there was no reason to believe that that level was... I mean, there was nothing in the evidence that suggested that level was unusual. As I say, it had been recorded over a period of time. There was obviously evidence, which is referred to in the Court of Appeal, about the potential cessation of domestic waste being received. But that evidence in relation to domestic waste being ceased was subject to a caveat that there was still an issue about the effectiveness of gas collection. So it didn't predict, and I'm again subject to correction if I've missed something, it didn't predict what the levels of hydrogen sulfide would be. The other point I would make is that although I accept, as I've already indicated, that the standard was expressed as lifetime, if one looks at the difference between medium term and lifetime, there's a big gap, and there's no... the medium term figure is certainly a shorter period of exposure than that which would be experienced by someone who is living in an area. I can't remember the period, but it's a relatively short period. And so on the face of it, there is, even in the English regulation, there's a sort of, which is why it seemed to be being applied at Wally's Quarry in our submission, the only figure for a sort of exposure over a period relatively short was the lifetime exposure figure. Going on, as I say, the human rights standard, which again we submit simply couldn't be addressed in the context of a nuisance claim. Human rights standard is a judgment of the European Court of Human Rights in Fadayeva, cited with approval by the Court of Appeal in Richards. The passage of Richards is at 4829, paragraph 66.
4829.
4829.
Thank you.
66. And the standard is essentially whether or not the matter has been approached with due diligence and consideration had been given to the competing interests. And that, in simple terms, is why we focus on this failure to consider long-term residents, because in our submission, that is a failure to consider competing in the interest of the long-term residents and a lack of due diligence. On the face of it, what the Northern Irish authorities were presented with, following the approach of the English authorities in Wally's Quarry, was evidence suggesting there might be an issue with long-term exposure. That is rejected, but there's no attempt to try and assess the extent of the problem, if there is a problem, or what level would be safe for long-term exposure. The third remedy that was identified by the Court of Appeal, in one sense in passing, and I'm going to deal with this very quickly, partly because reading my learned friend's statements of claim, statements of case rather, it's unclear to what extent they really rely on this, was the Ombudsman. The Ombudsman is governed by the Public Services Northern Ireland Act 2016, which is at page 6268, the relevant passage that I'm going to highlight, which is section 21.
Sorry, what was the page reference again?
6268.
Thank you.
And that provides essentially that there is no power to investigate, subject to one exception, if there is a remedy by way of action, in court. That, on the face of it, we would submit would appear to mean you can't rely on the Ombudsman when you're applying for judicial, if you could apply for judicial review. That interpretation of the legislation is consistent with a judgment of the Scottish courts, the Court of Session in Scotland, in a case called McHugh, that we've drawn attention to, which is in volume 2, tab 21, page 5264, paragraphs 42 and 44. Now, I accept there's an exception if it is not reasonable to expect someone to apply to court, but no reason to believe judicial review wouldn't be reasonable in these circumstances. There are also issues about the extent of the Ombudsman's power, which we've identified. Ultimately, the Ombudsman sees section 23.1, which is at page 6270, is concerned with maladministration. And it's, we would submit on the current state of the law, unclear whether, for example, you can bring a claim based on maladministration, arguing Human Rights Act grounds in circumstances where, for example, a public authority may have directed itself in an understandable way, but actually just got the law wrong. Turning to the law in relation to alternative remedies, starting point in our submission is it is important in principle, although I accept the case law rarely does this, to distinguish between whether or not, in fact, there is something that can genuinely be described as an alternative remedy, and then whether the court should exercise its discretion to, in any event, permit the judicial review to be heard. Now, the reason why in my submission it's important to draw that distinction is if, in fact, there is no alternative remedy, by refusing to hear the claim, what you're doing potentially is, or what a court is doing potentially, is denying the person who wanted to bring the judicial review access to the court. Now, we submit, obviously, in relation to this, that if the alternative remedy is directed against a different party, is considering different issues, and in particular doesn't determine whether a public authority is acting lawfully, then that can't be an alternative remedy, because it's not permitting the person who wants to bring the judicial review application a right of access to the court to have those issues resolved. Now, we, in our pleading, made the point, in our written case, made the point that, as far as we'd been able to find, and I add the same caveat I've added at several points before, you don't know what you don't know, the number of examples of cases where effectively where someone was found to have an alternative remedy as a result of private law proceedings against a different party is extremely limited. We could only find one case. That there may be arguments that there are a couple of other cases based on other people's cases. We would distinguish those, but it may not focus. What's perhaps telling, though, is that the first respondent's case in response to that is to accept that this is an extremely rare thing, but to indicate that's because, to use their language, most cases are either-or cases. That's the language they use in their written case. In other words, you either bring a judicial review or you have a statutory right of appeal. And it's clear we would accept that most of the cases are about that issue, which may be an indication that this is somewhat of a radical step. And this clearly isn't an either-or case. An either-or case arises where there's a statutory right of appeal that says you can challenge the legality of this public authority's decision by appealing to this tribunal or something along those lines. And that presumably explains why, in one sense, no party, it wasn't just the appellant, cited the linked judicial review, or the Alpha Resources case. Because the Alpha Resources case is quite clearly a classic either-or case. No question. And the focus of the Court of Appeal, I won't take, it's at page, that starts at page 4739. The focus of the Court of Appeal in that case, quite correctly in our submission, consistent with this focus on either-or cases, was essentially to consider whether the scope of that appeal actually allowed Alpha to raise the legal issues they wanted to. And you see that particularly at paragraph 33 and 34 of the judgment.
Which page is that?
Sorry, I gave the page for the first page. I'll just find it for you.
Or just the first page again?
The first page is 4739.
Thank you.
Well, that's where the issues are set out, certainly. 4753, I'm told by my junior, who's ahead of the game, is where 33 and 34 is. So we submit that's a perfectly conventional application of alternative remedies. It was a case where there was a statutory appeal, no question that you could challenge the public authority. Only issue was essentially whether the scope of that appeal allowed the issues to be raised. Court of Appeal, unsurprisingly, in light of case law, found that the issues could be raised. Now, because in one sense the case law directly relevant is so limited, in our submission it is appropriate, relevant, to go back to first principles, which is what I've already started on, and look at principles such as, in particular, the right of access to the court. I won't take you to it. I'm sure this court's extremely familiar with it. The unison judgment, which is at 4867, paragraph 66 onwards. But at paragraph 68 in particular, having set out that right of access to the court is a constitutional right, the court at 68 indicated that one of the reasons for that is because the courts ensure that the executive carry out their functions in accordance with the law, which is obviously what's in issue in this case. And to enable the courts to do that is to enable the courts, or the reason why it's important people can bring their claims is because it enables the courts to carry out their role. And that's the context of quite an important point made, which is is made at paragraph 69, which is that the right of access to the court is not only of value to individuals. And that's important in a case like this, in my submission, because whatever the appellant's fundamental motives were, we would say, consistent with Unison, what she was doing by bringing a claim, whatever her motives were, was enabling the courts to determine whether criticisms or challenges, rather, to the legality of the actions taken by important regulators, whether that was lawful. And that does fulfil a public service. And we submit in relation to that right of access to the court means that in one sense it's not open to a court to do what the Court of Appeal did, essentially, which was assess the motivations and decide for itself how those motivations, how the objectives, rather, of the appellant could be achieved. And it's open in our submission to someone to say, I actually want the regulator to do the job. Now, that reliance on the right of access to the court also is supported, we submit, by consideration of the case law regarding ouster clauses. Now, this is obviously not an ouster clause. I'm not suggesting it's an ouster clause. I'm not suggesting it's directly on point. The reason why I draw attention to it, probably obviously, is because what that case law makes clear, consistent with what I've already drawn attention to from Unison, is that judicial review plays a particular constitutional role by ensuring that public authorities are taken into account. And that's relevant here because, as I say, the approach of the Court of Appeal potentially left the appellant without any role in relation to, or any remedy, rather, in relation to the legality of the actions of the public authority. The reference to in the divisional court will be again very familiar. I won't take you to it. It's page 5563 of the bundle, paragraphs 31 to 37. So that's where we start. We start from saying, look at the first principles. First principles suggest that where someone is saying, and in circumstances where it was obviously accepted by the High Court that this was arguable, where someone is saying that a public authority is failing to comply with its obligations, particularly in such an important area, they have a right of access to the court. The fact that they might be able to sort of take other steps to against the private body that is subject to regulation doesn't mean they're not entitled to say, I want regulation to be effected in a lawful manner. That distinction that I've been seeking to draw, that issue of principle, in our submission is reflected in both English and Northern Irish case law and recent case law. We've already drawn attention to the Alpha case. As I've already indicated, Alpha was a case where the issue wasn't whether or not there was a set of proceedings or a set of whether or not there was a procedure which meant there was no need to consider the legality of the public authority. In Alpha, the whole focus was on the extent to which the legal issues that the applicant sought to raise in the judicial review could actually be considered in the appeal. And that focus on the legal issues in our submission is also consistent with an English Court of Appeal authority, Watchtower Bible and Tract Society, which is at volume 1, tab 9, page 488.
488?
Yes.
Is that the electronic page number?
Yes, it should be the electronic page number. 488.
That's all right.
Sorry,
yeah.
I ran out of 8. In that case, there was what the issue was, and it's just worth understanding because it is in one sense telling. The issue there was that there was a challenge, as you'll see from 488 paragraph 5. There was a challenge to two separate decisions. One was the initiation of an inquiry by the Charities Commission. One was a production order. In relation to the challenge to a decision to initiate an inquiry, Court of Appeal held there was an alternative remedy, and that wasn't at all surprising. And you see that paragraph 20 is where it starts, and the conclusion is at 25. And that wasn't surprising because if you look at paragraph 17 and 18, section 321 of the Charities Act provided jurisdiction for the first-tier tribunal for a review of a reviewable matter, and a reviewable matter was the it was the decision to institute an inquiry, and that's at 18. So quite that language of review, it's not language of appeal, obviously, but it, on the face of it, would clearly cover any sort of public law issues that an individual wanted to raise or a charity wanted to raise. What's telling, and this is why in one sense I put so much focus on it, is that the approach to the second issue was different, or the outcome of the second issue was different. In relation to the second issue, the production order, there was also an appeal which was governed essentially by section 320 of the Charities Act, which is set out at paragraph 16. But that appeal was limited to essentially whether information requested related to a charity and whether it was relevant to the discharge of a function. So the Court of Appeal then, looking at that, directed themselves, and you see this direction at paragraph 33, directed themselves that the critical question was the scope of the appeal. And the issue essentially turned on whether the statutory phrase could be extended to include effectively a review of whether or not there was a lawful request for the documentation. And the Court of Appeal concluded ultimately they couldn't, those words couldn't be extended to include a lawful review of whether there was a lawful request for the documentation. And that led to a conclusion essentially that there was no alternative remedy in relation to that second decision. So what you see there in my submission, entirely consistent with the point I'm making, the first stage of this process, before considering discretion, is to look at the scope of the appeal and whether that appeal, in fact, allows the issues to be raised. And that's entirely consistent, we submit, with the points I made about the right of access to the court. If you have an appeal and you can raise all the issues you want to raise, there's no problem with the right of access to the court. In Northern Ireland, probably the leading judicial review case of the Court of Appeal on alternative remedy is the Ballyedmond application, which was about a judicial review of a cost decision made by magistrates, which cited with approval a judgment by Beloff and Mount, not a judgment, an article by Beloff and Mountfield, and you see that at the bottom of page 4760. Much of that was concerned with the second issue, which is the exercise of discretion, but it's worth just looking at for this point. If you look at page 4761, where the principles identified by Beloff and Mountfield are set out, there they talk about para C, what is the most efficient and convenient method of resolving a dispute? And would the alleged alternative remedy be equally efficacious to solve the problem before the court? Now, that focuses on the issue before the court. Here, the problem is the alternative remedy won't say anything about the issue that was before the Court of Appeal. Certainly the common law negligence and statutory negligence won't say that. They will deal with a different issue, which is whether the private authority, the private body rather, was responsible for nuisance. That's consistent with the textbooks. There are a number of cited. Just to give two examples, two examples that are general and two that are focused on Northern Ireland. In terms of the general ones, Lewis Judicial Remedies in Public Law, page 4916, paragraph 12-44. Important issue is the adequacy of the remedy as a means of resolving the complaint. So it's focused on what the issue is in the judicial review. Forden, 6301, paragraph 36.1.
Sorry, 6301.
6301 of the electronic bundle.
Paragraph
36.1.
Thank you.
Judicial review is not the sole legal protection against legal wrongs by public authorities. The existence of other avenues affect whether judicial review is available. Judicial review is an ever-present safeguard against public authority action. So it's suggesting that what's key is whether or not there is some other form of legal protection against legal wrongs by public authorities, not whether there's some form of civil claim. Give you Northern Ireland focused text, not that I can detect any real difference between the approach in Northern Ireland and England and Wales in this area. Page 4919, Larkin and Schofield, paragraph 802. It would normally not be proper to seek to challenge by judicial review where a decision can be challenged through statutory appeal. Again, the focus on the decision. Professor Anthony, junior for the first respondent, in his book at 6326, para 3.79, case law has seen courts reject arguments about alternative remedies where the nature of the alternative remedy not suited to resolving public law issues. May explain why the first respondent didn't raise this argument in the High Court and didn't raise this argument on appeal. There was no respondent's notice from the first respondent. All of those mean, in our submission, that as a matter of principle, our arguments are right. Now, I'm not going to take you to, because I'm conscious of the time, the detail of the sort of cases where this issue sort of has been raised. For your note, just so you understand our points in relation to it, Moya, which was the case we raised as being one where an alternative remedy was found to be civil litigation, is at page 4800. It starts at there. What we would point to is the fact that, firstly, those remarks were obiter because the public authority was, in fact, not, well, it wasn't the public authority, it wasn't open to judicial review. That doesn't seem to have been raised as an argument. It says very little, we would submit, at this level that's of value. My learned friends, I think one of my learned friends raises Holmcroft as being another example of that. I'll just give you the reference, which is page 4786. There, in fact, alternative remedy wasn't an issue. The issues that had been raised were whether the decision was open to judicial review and then whether the procedure was fair. And the issues, the comments about the availability of civil proceedings, which you find at paragraph 58 onwards, were effectively made in the context of dismissing the arguments about procedural fairness. Against that, we would emphasise the Everett case, which is at page 5922, the relevant passage really at para 5933, where the court rejected, in very similar circumstances, because the issue was in the Environmental Protection Act and the availability of statutory nuisance proceedings, the court rejected alternative remedy on the basis that the local authority was the primary enforcement authority. That's the case here. That's the the scheme of the 2011 Act. The 2011 Act makes it clear that the public authority has primary responsibility because it has freestanding duties even if there is no complaint. The other authority we've drawn attention to as being potentially relevant is the Corporation of London case, which is at 5589.
Sorry, can you give me that number, page?
Sorry, 5589.
Thank you.
The reason we draw attention to that is because in one sense it might be said to be similar, because the underlying motivation of the claimant essentially was an economic one. And in relation, and you see that at paragraph 11, and in relation to that economic remedy or economic concern, there was a private law remedy. One market could essentially sue another market. And you see that at paragraph 15. None of that led to a finding that judicial review was inappropriate at paragraph 16, because ultimately the issue that had been raised was whether the Secretary of State had exceeded his or her powers. So the response of the court was essentially to say, it was essentially to accept that there was a right to the determination of the public law issues that the claimant in that case wanted to bring. Now, my learned friends, I think the first respondent says, well, that was because the case centred on the lawfulness of the Secretary of State's consent. That's true, but that's because that was how the case had been structured by the claimant when they brought a judicial review set of judicial review proceedings. Same as here. The actual case before the Court of Appeal was about whether or not it had been in compliance with legal obligations by public authorities. Finally, one needs to also bear in mind that there is an analogy here with criminal prosecution. Now, the court will be very familiar with the fact that there are numerous judicial reviews. I say numerous, obviously, because it's a high threshold. There's not vast numbers, but there are regular judicial reviews, is perhaps a better way of putting it, of decisions not to prosecute. Now, Lord Bingham in Manning, I'll give you the reference to it, it's 5949 of the bundle. Get the paragraph number, sorry, there is a paragraph number. It made it clear that judicial review, although it's a high threshold for challenging a prosecution decision, it shouldn't be set too high because it's the only way, it's paragraph 23, the last few lines of paragraph 23, because it's the only way, essentially, that an ordinary citizen can obtain relief. Now, that's and the approach of the Court of Appeal would essentially mean, we would submit, because there's no obvious distinction to be drawn, that it would be potentially very difficult to bring judicial review proceedings of prosecution decisions, because the answer would always be you can apply for you can bring rather a private prosecution. Now, my learned friends point to ex parte Camelot, which was a situation where there was a judicial review brought by one lottery, essentially, of a decision not to prosecute a rival lottery. And in that case, the DPP had concluded that the rival lottery's actions were not unlawful. You see that on page 4903. What the Divisional Court did was apply a set of principles at 4912 that started with the principle that criminal disputes should best be decided in criminal courts. And that was then applied with particular rigour because at para 7 it was noted that effectively it was particularly undesirable for there to be a decision as to criminal liability by Party C in proceedings against Party B, which was the DPP. And that was the particular problem in that case. And one can see why alternative remedy might be a particularly strong argument in that case, because the fundamental issue was whether the lottery that was said to have acted unlawfully has in fact committed a criminal case. Private prosecution would determine exactly that issue. So having a judicial review essentially to determine whether the actions of the lottery were criminal were effectively asking the court to determine precisely the issue that would have been determined on a private prosecution, not this case. I'm going to pass over very quickly. We do point to the fact that in relation to Article 8, we submit there is an express, well, there is a clear right, based on the case law of Strasbourg, to have a determination of the Article 8 claim domestically. The authority for that is Scordino, page 6107. And that makes it clear that someone remains a victim of the human rights violation unless the victim has been acknowledged domestically and appropriate redress has been granted. The right to bring private law proceedings, even though we accept, obviously, those proceedings would need to be conducted as far as possible compatibly with the Convention, is not is not permitting a set of proceedings to be brought where there will be a finding as to compliance with the Convention. It says nothing about whether the public authority has acted compliant with the Convention. Finally, and I'm going to deal with this very quickly in the time, there is, on the assumption you're with me on the first issue, before one gets to the issue of ground 2 and whether there's an arguable case, we would submit in relation to ground 2 the issue ultimately must be arguability, in part because otherwise there is no consideration of this at first instance. The final issue is whether the appeal is academic. The Court of Appeal, in its judgment, considered the fact that there may be no more material dumped and that the landfill may be capped, but raised the issue that, of course, which we would say is correct, rather, raised the issue, and it's paragraph 62 of the judgment, page 226, raised the issue of the potential risk of gas escape and the potential for that not being captured. Now, in our submission, it is not surprising that, firstly, it's not been demonstrated that that factual finding was wrong, and we've also raised issues about whether it's before the court. But ignoring both of those points, in our submission, what in fact the evidence demonstrates is that those concerns about capping were legitimate. If you go to, and this may also be relevant to the question I think my Lord Stevens asked me about sort of the long-term risk. If you go to page 2525 in the material, this is another bit of I think the first affidavit of Mr. Miller, the principal scientific officer within the Northern Ireland Environment Agency. Paragraph E, he indicated that his view was that current gas collection efficiency was 78%. And he indicated that once fully capped, it was anticipated it would be 83 to 93%, which he said was a good rate. That, on the face of it, means that the capping doesn't completely prevent gas escape. In fact, the gas escape isn't necessarily that much lower or the collection rather, to be more accurate, the collection isn't necessarily that much more efficient. Certainly there was no basis for concluding that there would be no effluent gas. That needs to be viewed in light of the fact that the legal obligations we submit continue. In terms of the legal obligations, Section 64B continues to apply. It's not limited to situations where, for example, waste is still being received. In relation to the second and third respondent, I didn't take you to it, but I'll give you the reference to it. It's page 6209 to 6210. One of the factors that needs to be considered when effectively providing a permit for the site is at regulation 11.3e, the plant must be operated so that upon cessation of activities, necessary arrangements to avoid pollution of risk are made. We wouldn't necessarily accept that there has been cessation of the operations because of the fact, as you've seen, there is reason to believe gas will still be produced. But even if we're wrong, there is still clearly an obligation on the regulator, the second and third respondents, to play a role in ensuring that pollution is prevented. And consistent with that, to be fair to the respondents, you've got a supplementary bundle, which we've raised questions about whether or not, given the role of this court, is properly before the court, but in any event, addressing that material. Mr. Miller, in his supplementary bundle 11, paragraph 6, notes we would submit consistent with the...
Sorry, which page are you on now?
Sorry, supplementary bundle 11, page 11, rather.
Page 11, right. Thank you.
Notes that there'd been 7 inspections of the site, and at least on one occasion, odour had been detected. Odour obviously isn't necessarily the same as a level of H2S above 1 part per billion, in part because it's clear that, I'll give you the reference to it, it's 2854. The odour threshold is generally thought to be apparently 8 parts per billion, but at least on one occasion, odour was detected. So you see there that regulation continues. And obviously the applicant's, the appellant's affidavit rather is that odour continues. We also say in passing, I should say, that the matter isn't academic in part because there was also the claim for a historic breach of the ECHR, but that may depend on the court's view of the merits of the arguments I've just put. But certainly we do not accept that this matter is academic for those reasons. We started late, but I think I've sort of broadly caught up with time. I don't know whether there are any...
Brought it in almost exactly on time.
Yes, so I don't know whether there are any questions.
I don't know if there are any questions. I don't know if Lord Stevens
Yes.
has any questions.
Thank you. Yes, I could. If I could just bring Mr. Suddy back to the lifetime levels,
Yes.
which is, you say, is 1 part per billion, relying upon, you say, a reliable source. And I asked you a question as to whether there was any evidence as to whether the level of sulfur would decrease over a period of time. Do I understand it to be your case that really that's a matter for the regulator to investigate?
Yes.
Rather than for you to bring evidence about, so that the regulator, if it anticipates that, well, first of all, you say that there is an obligation for the regulator to actually consider what the relevant standard is on a lifetime basis, and then once it's done that, to see whether this particular site would breach that over whatever is meant by a lifetime. And in order to do that, it would have to form some sort of assessment as to whether or not the 3.31 parts per billion will decrease substantially over a period of time. Do I understand that case?
My Lord, absolutely. My Lord may remember. Can I just the ground, the order 53, the ground set out in the order 53, or at least one of the grounds in the order 53, said, and it may be just worth looking at that because it provides the context of the question. My Lord said, if I can find the order 53.
Well, I hesitate to say this, Mr. Southey, but I find your Order 53 to be one of the most complicated documents and confused. But all the same, let's have a look at whatever page you're looking at.
In defence of myself, that may be the product of Richards, but the High Court, and maybe we should have provided this, had a clean copy as well, so which simplified matters.
Well, could you provide a clean copy, please?
Yes, I'm sure we can. Yes. My Lord, if you go to page 377, para 4C, you'll see that what is said there is that the monitoring was undermined by the absence of any clear standard, effectively, and that's, we would submit a reference back to the lifetime standard, and that's the point, is that...
Well, I don't find that to be a focus on the lifetime standard at all. But anyway, be that as it may.
But, my Lord, the point that we were making fundamentally was that if what had happened in England, and we submit this is consistent with sort of correct approach, essentially, is that and you saw this from the paper, is there'd been identification of what were standards where there were believed to be the risk of health issues. That then drove the monitoring, because what followed was, because it's in one sense very difficult to see how you carry out effective monitoring if you don't know what it is that's going to give you a concern. And in relation to life...
That's what I understood your case to be, yeah. That a regulator, in order to regulate, should actually understand what the standard is that is applying. Yeah.
And that's why I said, my Lord, in relation to the point about 1 part per billion, if the regulator, if the second and third respondents had come back and said, well, we've looked at this standard that the US have adopted and then that's then been applied at Wally's Quarry, and we understand that says that there is a risk through lifetime exposure if the lifetime exposure is over 1 part per billion. But we've also spoken to these regulators who have carried out studies who tell us, in fact, that's massively overcautious and the safe standard is 10 parts per billion or whatever it would be. That would be very different, because that would be the regulator coming up with a conclusion as to what long-term exposure was safe, and then applying that. But what one has here, we would submit on a fair reading of the evidence, is the rejection, essentially, of a standard that had been adopted elsewhere, and then but without any real engagement as to what was a long-term safe standard. In circumstances where, and I accept it was limited, but it is the only evidence that we'd seen, what had been said by the regulator is we don't have the capacity, effectively, to carry out our own assessment of what is safe. We have to rely on others. Well, I hope that's probably an overfull answer, a response to my Lord's question.
Thank you very much indeed.
Thank you. Thank you, Mr. Southey. Cole.
Thank you.
Mr. McAleenon going to bat first.
Yes, I'm going to address the court first for the second and third respondent. Apologies. Mr. Cole will follow on in respect of that. I appear with Ms. Mulholland for the department in respect of this matter and the agency. This is one of a number of judicial review applications that emerged in 2021 in relation to the Mullaglass landfill site. And as the court will see from the Order 53 statement, page 370 of the papers, This has been something of a rolling judicial review which has evolved and developed with complex pleadings introduced and dropped as the case went along. But what's apparent from reading that document is that the initial concerns of the applicant certainly involved concerns about the abatement of nuisance. There was an application for interim relief. You'll see that in the Order 53 statement. There were also pleadings in respect of damages for nuisance and damages for breach of the convention rights. And I highlight that because I'll come back in due course to what's available under the statutory scheme in that context. So those were.
I think, Mr. McAleenon, there's a problem with the angle of the microphone. That's what's causing the
Feedback?
Yes. That might be better now.
That's better, yes. Thank you. The Order 53 statement in its final incarnation has a point which has loomed large in the discussions today at page 376, paragraph 4A. And I'll deal with this point first, if I may. You will see how the case is pleaded in that paragraph. It refers to the guidance values apparently adopted by Public Health England have apparently been rejected on the basis that pollution levels are lower than those of the English side, Wally's Quarry. And that's a centrepiece of the case, that in essence there's been some kind of standard applied, generalised level in England that is not being met in Northern Ireland. And the court will notice the use of the terms apparently there, because in fact the evidence before the court is that there was no generalised standard applied by the authorities in England and Wales in respect of the emissions of hydrogen sulphide. And the court's picked up some of this already in its exchanges with Mr. Southey. But if one goes back to the source document for this, which is at 2098 of the appendix, this is the UK Health Security Agency assessment in respect of the Wally's Quarry site in a period from March to August 2021. And as has already been discussed, this was a case that led to litigation in respect of a particularly sensitive receptor, a boy who had a particular respiratory concerns. And in page 2098, you'll see some guideline figures in respect of hydrogen sulphide. And the left-hand column, you have World Health Organization quality guidelines, and you'll see levels there of 5 parts per billion for a 30-minute average, 107 parts per billion for a 24 average. And over at the right-hand side, you'll see the most sensitive threshold conditions under the US EPA of 1 part per billion based on studies in rats and the presence or absence of lesions in their nasal olfactory epithelium. And you'll see the footnote to that, 3-star asterisk at the bottom, refers to that being an estimate with uncertainty spanning perhaps an order of magnitude of continuous inhalation exposure to the human population that's likely without an appreciable risk of deleterious effects during a lifetime. So this is the most sensitive possible standard based on studies in rats, not humans, with inhalation over a period of 365 days of constant exposure. So,
could I inquire, sorry, Dr. McAleenon, could I inquire as to what standard your clients applied?
Well, they didn't apply a standard specifically. What they did was they
how can they regulate if they don't know what standard they're applying?
Well, you regulate, Lord, by reference to the permitted activities under the statutory scheme. And you then. How
do you know what to permit under the statutory scheme if you don't know what is a lifetime harmful effect?
Well, Lord, there is no assessment of lifetime harmful effect in hydrogen sulphide in any of the agencies that operate in the United Kingdom. That's because there is nothing that can be replicated in reality that would match constant inhalation for 365 days per year of that level. Because
and is that explained in any affidavit or?
Yes, there are affidavit evidence from Mr. Miller and Mr. Crummy, which I was going to refer the court to deal with all of this, because this was the subject of contention and dispute in the High Court, and there's actually a finding by Mr. Justice Humphreys about this, which we say actually disposes of the issue. But I highlight this because the 1 part per billion standard that's relied upon by my learned friend is one that was an extreme scenario that was never actually applied in practice by any of the regulatory bodies in England and Wales. So it isn't a generalised standard. So when we go back to the Order 53 statement and the pleading about guidance values adopted by PHE in England and Wales, that's not the case. And there is, we say, a fundamental flaw in the premise of the entire application. Now,
you said a moment ago that Mr. Justice Humphreys decided this and disposed of the issue. Can you refer us to the paragraph, please?
Page 257, paragraph 79.
Thank you.
Perhaps picking up at 78, touches on Lord Stephen's point. Key conclusion needs to respond is the levels of hydrogen sulfide emissions are not in the evidence available considered by them, such as to require enforcement action, so below any threshold. 79, it's apparent the applicant wishes there be in place some limit, standard or guideline by which the emission from the site would be measured. However, the evidence before me is to the effect that no landfill site in the United Kingdom operates with a particular H2S emission requirement or guidance figure in its permit. And it's impossible to say the failure to introduce such a figure into the permit for this site represents a manifest error of appreciation. So that's the finding of the court, was that there isn't actually a standard applied, and that's drawn from the evidence that was before the court. There are two affidavits which have been opened to you in part that touch on the topic. The affidavit of Dr. Crumey, which you find at 3677. And he deals with this issue at paragraph 22, I think. I may have missed a reference there. Sorry, it's his second affidavit. That begins at page 4031.
I'm sorry, it's paragraph 22 of...
Sorry, it's his second affidavit, my lord, yes. Which begins at page 4031.
So was the 3677 a wrong page number?
Yes, there's a wrong page number. I'm sorry about that. That was his first affidavit.
4031.
4031, yes. And he deals with this at paragraph 22 of that second affidavit, which is page 4038.
Sorry, 4031 is the first one. And then the second one?
4038.
4038.
Paragraph?
22. You've already, I think, seen these paragraphs, but 22A. This is dealing squarely with the suggestion that there's a standard level, and Dr. Crumey is saying he's not aware of that in paragraph 22A. And at 22B, he refers to the fugitive emissions on this site, which are, he compares to Wally's Quarry. Longer-term monitoring on the edge of the site and in the neighbouring community by Tetra Tech has not indicated any cause for concern in relation to 1.3 part per billion level as an average likely over 365 days. So there is no standard applied across the United Kingdom in respect of that. The standard level that is identified is not a cause for concern on this site, and the affidavit evidence on that is what led the judge to reach his conclusions in that regard. There's then the affidavit of Mr. Miller, which you'll find the relevant section of this is at page 3830. And you'll see this is dealing here, paragraph 5, with his engagement with senior air quality advisors in the English Authority in respect of their approach. And 5A, no condition in the environmental permit issued to Wally's Quarry that requires the ambient air levels to meet a proposed standard. And that's because ambient air levels can be influenced by other factors, he says, not within the control of the operator, and can lead to inadvertent breach of the permits. Then to have a permit condition for every single pollutant would impose onerous obligations, and the official in the English Authority is not aware of any other landfill sites in England that are subject to permit limits regarding levels of H2S. So there is no 1 part per billion general standard that's applied across the United Kingdom. So insofar as the basis of the claim is that the Northern Ireland authorities have fallen into legal error, as is suggested in the Order 53 statement, paragraph 4A, which is a mainstay of the case, that was found by the High Court judge to be untenable. The point, again, was obviously influential with the Court of Appeal when they came to consider the issue. So we say, and again, one looks to the way in which this case shadowed the Richards litigation, and the Order 53 statement adapts and changes with Richards. Ultimately, the Court of Appeal in England was very clear that it was not the court's role, using the Human Rights Act and Article 8 of the Convention, to impose specific values by way of declaratory relief and set standards for the expert authorities. And the Court of Appeal was highly critical of the first instance judge for doing that. Our High Court followed the approach of the English Court of Appeal quite properly and didn't seek to take that course. So we say again, it is a case that failed properly on its merits in that respect. I wanted to deal with the statutory scheme that applies to cases of this nature, because this provides some of the answers, I think, to the alternative remedy argument and the discretion which the Northern Ireland Court of Appeal, we say, quite properly exercised. The statutory scheme for Northern Ireland in respect of statutory nuisances and pollution of this type mirrors exactly the scheme in England and Wales, so there's the same statutory framework. In Northern Ireland we have the Neighbourhoods and Environment Act 2011. I'm going to take you to that in a moment. And Part 7 of that is the key section. That is a direct parallel with the Environmental Protection Act 1990 in England and Wales, which deals with statutory nuisances and clean air at sections 79 to 82. So Part 7 of the Northern Ireland Act maps exactly to the English legislation in 1990. There is then provision made in the Article 4 of the Environment Order, Northern Ireland. I'll take you to this in a moment as well, under which regulations were made dealing with pollution prevention and control, industrial emissions. There's a parallel regime in England and Wales in the Environmental Planning Regulations 2016. So what we will see is that Parliament has devised and the Northern Ireland Assembly has adopted an interlocking statutory scheme for the regulation of nuisance and pollution. And it involves a number of actors. In the Northern Ireland context, it involves the Department. It also involves the local authorities or councils. It also has a residual facility for members of the public to seek to bring enforcement action themselves. So it's exactly the same scheme that applies right across England, Wales and Northern Ireland. And what we say is, in this context, Part 7 and the related statutes provide a lex specialis, if you like, for regulation in this field. So there ought not to be very many judicial review applications dealing with these points, because Parliament has enacted machinery in order to allow for these issues to be addressed. And if I can just show you Part 7, which is of the Northern Ireland Act, which is at page 6128. Of the authorities. See how the scheme is supposed to work. So this makes provision for statutory nuisance. The equivalent provision in England is section 79 of the EPA 1990. And you'll see at 63(1)(d), one of the statutory nuisances is smell or effluvia arising on industrial, trade or business premises. That's the issue in play here. So provisions made for statutory nuisance in that part of the Act. If you turn to 6135, you will see subsection 14 makes provision for a district council.
Right, with 6135?
6135, yes.
Thank you.
And this again is equivalent to section 79, subsection 10 of the English statute.
Sorry, we're going to subsection
14, Lord.
14. Thank you.
This allows a district council to institute summary proceedings in respect of a nuisance of the type we're considering, but they can only do so with the consent of the department. And this is important. This is where the parallel regulatory regimes intersect with one another. So the department can itself bring regulatory or enforcement proceedings under the Environment Northern Ireland Order 2002 or the Industrial Pollution Control Order 1997. And if it's a case which they could prosecute, then their consent is required before a district council can do it. So in this case, what was happening in this case was the applicant was asking the council to take action. They were quite properly looking to see what the department were doing because they've got a parallel enforcement regime, and between the two, judgment being made about the correct approach. So you'll see here, this is an interlocking statutory scheme. There's facility for summary proceedings. You'll see that at 6138 for statutory nuisance. So 65(1), where a council is satisfied a statutory nuisance exists or is likely to recur, they can take certain steps, including abatement, execution of certain works, so on and so forth. That happened in this case because Belfast City Council, in response to a threatened judicial review application, brought abatement proceedings against the landfill site. So they used this part of the Act. So Part 7 was engaged in the specific context of this landfill site. You'll see at page 6139, subsection 8, allows for a right of appeal by a party served with the notice to challenge that.
And that's what led to the judicial review by Alpha.
Yes. So Alpha
should have appealed.
Yes. So Alpha brought an appeal, first of all. Yeah. So they engaged Part 7 as well, and they brought parallel judicial review proceedings, doing both. And all this happening at the same time, May, June, July 2021.
And the provision for an appeal is in?
It's in subsection 8, the bottom of page 6139.
58. Thank you. Thank you.
And then you'll see the offence provision is at the top of 6140. So this is the offence of not complying with an abatement notice. You'll see at subsection 11 the hefty fines that are available for a case involving a trade or business, as in this case. And then you'll see at subsection 12 the defence. So it's a defence to prove that best practical means were used to prevent or counteract the effects of the nuisance. And that's a defence that's available to a business case. So again, you'll see the same concepts appearing in different parts of the statutory scheme. The operator will come back saying, we've been using best practical means, we have a defence, and that's a factor which will be weighed in the overall balance. The Act also allows for direct access to the High Court in certain circumstances, and that may be of significance, in section 67. Subsection 7, again, this is a parallel provision with the EPA in England, in section 81, subsection 5. So this is the bottom of 6146, where the Council is of the opinion that proceedings would afford an inadequate remedy in the case of any statutory nuisance. It may take proceedings in the High Court for the purpose of securing the abatement. So you see again, the statute provides a gateway into High Court proceedings where a council forms the view that the remedies available to them may be inadequate. In other words, injunctive relief for something that they couldn't do. But again, one sees here express provision made for the High Court action.
So what section is? I can see the subsection. What section?
That's section 67.
Thank you. 67.
Again, parallel is 81, subsection 5 in the EPA. So, you see the scheme allows for regulation by the department. I'll come to that in a little detail in a second. It also allows for enforcement action by the councils if they have the consent of the department. But if neither of those public authority actors decides to intervene, then there's a provision made in section 70, this is page 6153, for persons aggrieved to take action. And you'll see that again parallel with Section 82 of the English legislation. A court can act on a complaint made by any person on the ground that they are aggrieved by the existence of a statutory nuisance. The court can act even where the nuisance has been abated, if it's likely to recur. They can require the defendant to abate the nuisance or prohibit it and impose a fine on the individual operator.
But it's implicit, isn't it, that the defendant is simply the site operator?
Exactly, yes. That's not in dispute at all. You'll see, again, of some relevance to this case, this provision also allows for obviously a hearing of the matter, but also allows for complaints seeking compensation to be heard. That's subsection 15, page 6156. So, again, bearing in mind that this applicant brought proceedings seeking compensation, seeking an abatement of the nuisance, and still seeks historic compensation, you'll see that that provision, subsection 15, allows for compensation even if the nuisance is already stopped.
But it's only compensation for expenses properly incurred in bringing those proceedings.
Yes.
It's not damages for nuisance.
Well, yes, I agree, different than that. I see the time just turned to 1 o'clock, but I wanted to show the court briefly one other statutory provision which I'll flag now, which is at page 6200, the Pollution Prevention and Control Regulations 2013. So this is the scheme that the statute links to, and this is the scheme which the department operate. And Lord Stevens asked me about how the department regulates. The department regulates through a permitting system. You can only operate a landfill site with a permit. And this set of regulations, again, there's a parallel set in England and Wales, allows for the site to operate with permits, subject to conditions, and the requirement to use best available techniques. So the same concepts are employed by the department as by the council. And I'll show you how that connects together.
We'll resume.
Yes.
At 2 o'clock. Thank you, Mr. McAleenon.